Welcome to the SiGMA Roadshow, Las Vegas. We are sitting here with three panelists that are really the experts at licensing in the United States. I've been through it many times. We have an attorney who helps their companies get licensed in the United States. So I think we're going to present some great information. So I'm going to start introducing each of them one at a time and ask them to give their view on how difficult or how different it is to get licensed in the United States for a company that isn't based in the US. And I'm going to start with Marcus Yoder. Marcus is working for GAN, which is one of the leading platform providers for online gaming, both for social gaming, sports betting, and real money gaming. So Marcus, welcome to the show.
Thank you. Thank you. Yeah, I think one of the most important aspects for any company that is headquartered outside of the United States coming to the United States is really being able to show commitment. That's, the regulators want to understand if they're going to go through this process and license you into their jurisdiction, that you're going to be around, that you're going to actually serve the partners that you're going to be working with, whether you're a game supplier, or a platform supplier, sportsbook, or what have you. And so being prepared for that commitment in financial matters is incredibly important to go through the process.
Great. Okay, next we have in line CJ Fischer. CJ works for Fox Rothschild in Atlantic City. And of course, New Jersey was the first jurisdiction in the US to allow iGaming outside of Nevada, which only allowed poker. So CJ is very experienced in getting companies that are based outside the United States licensed. And of course, we think New Jersey is the gold standard right now, CJ?
Yeah, I would certainly say so. And I think New Jersey is a good example for companies looking to enter the U.S. market. And I think one of the more important things to be mindful of is just being prepared for what you're dealing with in a jurisdiction like New Jersey. Just a couple of key differences from European and non-U.S. jurisdictions is, number one, they are going to look at B2B companies. A lot of Europe regulators are focused on the B2C market. Whereas in the U.S., B2B companies do need to go through the process and get licensed. And in New Jersey and many other U.S. jurisdictions, the scope of licensing really extends beyond the applicant for the license. They're going to go up the chain of ownership, and not just with entities and owners, but also officers and directors of some of those entities higher up in the ownership chain. So being prepared for the extent of the licensing process is important to be mindful of before coming into a U.S. jurisdiction.
Okay, great. And finally, we have Richard Schuetz. Richard has experience in every aspect of the gaming industry, starting as a dealer in Reno, extending through regulatory assignments in California and Bermuda, and now we call him the guru of gaming. So, Richard, thanks for joining us.
It's beginning to sound like a eulogy. As Roger mentioned, I started in 71 as a dealer for Bill Harrah and have been in the industry essentially ever since. I understand a bit about regulation in that I have gone through 120, and that's an estimate basically, licensing investigations of myself, and that starts long ago in the 80s, and I've been able to witness the changes. As a matter of fact, I even did a PhD dissertation on the evolution of Nevada's regulatory system from 45 to 66. So it's really different. But one of the main points for Europeans to consider is you don't enter the U.S. market, you enter a state market, and you need to understand that. Really importantly, because the states have differences, and generally, and they've done a terrible job at harmonization. Generally, a state kind of steals someone else's program at some point, their package. But through the rulemaking process and whatnot, there's this evolutionary shift that through time they become fundamentally different, and that's just a real challenge. And so, if you go through the New Jersey process, for instance, don't think you understand what U.S. regulation is about necessarily, because it can be fundamentally different someplace else. And that's just a challenge. And that's why I would always encourage yourself to get help. I mean, being prepared for the licensing investigation is critical. And I think we're probably going to talk about that a bit, but that's the biggest step you take.
Okay.
don't try and figure it out on your own, because you can't. But
Right.
just as an aside, and the younger guys will appreciate this, when I went through the 120 applications, that each application was different. We didn't have the multi-jurisdictional process. And in Nevada, for instance, the lawyers kind of knew what each question meant, but in Missouri, it could be fundamentally different. And
Sure.
I mean, it just drove you nuts.
Absolutely. So let's stick with you, Richard. What do you think is the most important lesson that gaming companies coming to the U.S. must understand about regulations?
Is to be ready. You know, first of all, if you sit down with, and I've been a regulator too in two different, not only was an operator for 30 years, but I've been a regulator in two different environments. But if you sit down with 10 executives, I would argue and say, does anybody have any problems? You're going to get 10 no's, and 8 of those are going to be true. And the others aren't going to be impossible problems, but they can be tricky things that need to be managed. I would argue that the firm should background itself through different techniques that are available and services. And I've been involved in that in my time. Don't trust your executives to be fully honest. Background yourself. And that's both with regards to any criminal or civil issues, and also really any more that a lot of us follow the money, although Leon Black kind of demonstrated recently that they haven't been following the money too closely, apparently, with this $158 million payment to Jeffrey Epstein, which people seem to have missed. But I think, you know, you want to look at your own people, you want to prepare your firm. I think one of the most wise things that a lawyer can do, CJ, as an ad for you guys, is make sure your employment contracts are ready. Because if you have to get someone out of that organization, you don't want to start negotiating with him when you're, you know, in the lobby of the regulatory agencies. Right. You know, yeah, I need 3 million as my walk away amount. You want that defined. So if you have a problem with a person in the organization, you know how you're going to get him out of that organization. You're going to know exactly what it's going to cost. So those are just some of the things that just be ready. Last thing is, don't lie. I mean, people make up stories for the wrong reasons. A regulatory agency isn't there, for instance, to enforce a marriage vows. And if somebody's sending some money to a neighboring area that has a girlfriend or something, or a boyfriend, admit it. If they pick that up on your forensic accounting examination, that's not going to blow you up. But if you lie about that transaction, you're in trouble. You know, so just don't start lying. Just be honest, be open, and be prepared.
Right. CJ, what about you? What do you think is the most important lesson that people can learn about getting licensed in the U.S.?
Well, I think Richard touched on a couple of key points about being prepared from the licensing and regulatory point of view. I think an additional point that makes sense is operationally as well. If you're, you know, an operator, for example, trying to enter multiple jurisdictions, again, you're dealing with multiple states that are regulating your product, your offering differently. So from an operational point of view, and also tying into regulatory obligations, you're going to have the staffing and team in place to ensure that you're meeting those ongoing regulatory obligations in every jurisdiction that you're in, and also operationally being prepared for the cost involved. Again, if you're an operator, for example, that is looking to operate in multiple jurisdictions, you have the Wire Act to deal with, and some of those laws are going to add to your expense. Your expenses, because you're going to have to set up servers in different jurisdictions, staffing in different jurisdictions, different regulatory requirements in each state. So I think being prepared for knowing what those requirements are and how that's going to affect your bottom line is prudent to do, rather than just jumping into it and trying to figure that out later.
Okay. And Marcus, you work for companies large and small. What's your opinion on the most important lesson to learn?
Well, exactly what the two gentlemen just said, but one thing that can definitely help you out is structuring when you do the first application, structuring yourself for more applications, right? So for, you know, it is definitely worthwhile to take the entire financial statement PDF and convert that into an Excel spreadsheet, right? With ties that sums everything for you, so that after you do New Jersey, you're ready for Pennsylvania. You just need to update the amounts. Maybe you added an account, maybe you sold the stock or what have you. And also prepare anybody who's in your family who will also have to go through that. My wife was not ready for that, and it was kind of tough. For the state of Indiana, we had to submit 540 documents, not pages, documents of every visa, every shopping card, every account, every, I bought Bitcoin, everything had to be submitted. So when you do your first one, prepare yourself that you're going to do another one. Say, take the time and name the files correctly, and create this spreadsheet that you can update so that you don't have to go through the entire pain for the second one.
Right. Okay. So CJ, when I was a dealer in Atlantic City in 1978, I had to fill out a form that was 2 inches thick, and I was just a dealer, for gosh, and then recently, when I submitted a form for our affiliate marketing company, it was not quite as bad, but it was still very in depth. Now I've heard European executives come to me and say, I can't believe the detail I had to go into. So what do you tell the individual executives of what they're going to have to go through when they come to the United States?
Well, I think the first call, that first conversation has a lot of, you got to be kidding me moments that happen. So I think you have to, you get over that hurdle. And then it's, as an attorney, it's counseling them on how the process works and how I can help them in that process, talking them through filling out the multi-jurisdictional form, for example, which is 66 pages of pure fun, disclosing your whole background, all of your assets, all of your liabilities. And, explaining that to an executive, it's tough. They find it hard to believe, especially when you get to the point where you explain that that's only the start of the process. After that, you have the document requesting 3 to 5 years of bank statements, brokerage statements, and the like, and then also an interview with the regulator. But the good news comes in the sense, and I think Marcus touched on this, is you fill out that form once, you gather that documentation once, and when you get to the next jurisdiction, you can leverage that information, you can leverage that documentation. So instead of starting from scratch, you might need to fill out a new form, but the incremental hurdle for a new state is much less than when you first go through it in that first jurisdiction.
Yeah, so that's the big shock to the system at that point, I guess, that you have to see how much in depth you have to go. Richard, I can't imagine what you did in filing 120 applications at one time, but what happens if you get denied in one jurisdiction? I mean, we saw that a couple of weeks ago with a executive at one of the skill gaming companies in Vegas. We also saw in Indiana, one of the principals of one of the casinos that's planning to be built there, was tossed out. I mean, that's got to be something that you have to be prepared for as well, I imagine.
You do. A lot of my applications came about because I was put on the board of Shuffle Master Gaming, and they provided me with a couple lawyers and some staff members that kind of managed all that stuff. On one application, and it was the state of Missouri, they had made a mistake on the application, and the regulators had caught it, and that is dangerous because it can domino on you. And what we were able to do is I signed on that date, and I think Marcus will appreciate that I signed 29 applications on one day. I flew into town to sign 29 applications, and we were able to take to Missouri and show that the other 28 had the correct information, and it had just been a transcription error that the typist had made at that time. The other thing, Roger, when I did my New Jersey license in '84, when I worked for Mr. Wen, the agent put a gun on the table, because at that time every agent was armed. Right. They were all sworn officers. So it's gotten better. The
Right.
other thing, when I did my last, when I was appointed to the commission by Governor Brown in California, I showed up for my investigation and I had 7 banker boxes in the back of my truck. I said, what do you need? I've got checks to 72.
Yeah, Roger, I think that's an important point to make, that this is law enforcement. This is
Right. Yep.
my very first meeting with the DGE. The agent came in back in heat, for it was an interview with the regulator and an interview with an investigator from the state police. This is
I was with my accountant that had my tax records that flew back to New Jersey with me, and she was, well, I would call her elderly, although she is younger, or was younger than I am now. So she was quite young, I guess. But this guy pulled that gun out of his holster and set it on a conference table at a hotel there. I thought she was going to faint. She was thinking if she just made a bad deduction, she's going to get blown away. I mean, it's really intimidating, and especially new jurisdictions often rely on state police and have a very police type mentality. And you'll notice that Marcus, I'm sure, can relate to this. Some of those guys, when they do that first interview, it's like they're interrogating you for just having robbed a 7-Eleven, and they're looking for the body language moves and everything. And it's kind of weird, but when you bear with more professional jurisdictions or that have been doing it longer, it becomes very much a business type of interaction, and not they're not sweating you down with a spotlight.
So CJ, if somebody in your organization is rejected, what is the process at that point? Do you appeal it, or do you just say, okay, we'll find somebody else?
Well, I think it depends on the jurisdiction. I mean, you explore avenues for appeal. You see what's there from an administrative point of view. You also see, again, depending on what the issue is, whether the individual has any recourse to fix it. Again, depending on the issue, that might be an option. But if that fails, then door number 3 is typically termination of that individual. I mean, if you have an unsuitable individual affiliated with your company, or somebody otherwise denied a license, then the licensee cannot maintain its license, or it won't be granted a license. And generally the recourse would be removing that individual. There's plenty of instances, even recent instances of this happening. The Steve Wynn, for example, after all of those allegations, he was no longer a officer, director, or even owner of Wynn, and that's a good example. Wynn continues to be a licensed company. So really that would be the recourse. If somebody is found unsuitable or denied a license, and there's, all other avenues fail, then generally that person would be removed or terminated. And even from an ownership point of view, a lot of public companies, as examples, have in their articles of incorporation that if a owner is found unsuitable, that they're forced to divest or put their interest in a trust. Or otherwise the company can buy back their stock, and it's for precisely that reason, so that owner does not jeopardize the licenses of the company.
Okay, great. So Richard, I'm going to just ask you these questions. I don't want to put the other 2 on the spot here, but I know you'll answer it because you've written about it. But in terms of the actual commission members, I mean, up until this point, we've been talking about the staff members, the investigators, but the actual commission members are often political appointees, beholden to politicians, and this is kind of their payoff. I don't want to say payoff in terms of dollars, but I guess in some worlds it is. But how should a company look at the commission, when the actual members of the commission really have no gaming experience or just have political, payback there?
Well, most agencies are to some degree bifurcated. Like in California, it was a pure bifurcation. You had the commission that reported to the governor's office, and the bureau reported to the Department of Justice, and the attorney general was separately elected. New Jersey has a situation somewhat similar to that, but the attorney general is appointed. And then through the innovations made in iGaming, they kind of eliminated the importance of the commission to a certain extent. And CJ knows a lot about that. I think the main challenge that having lay people goes back in Nevada history to mob influence with the industry. And so they got people that couldn't know anything about the industry. I mean, this was my issue in California. I had the most expensive background investigation in the history of California. And that was because they assumed I was mobbed up because I had all these Vegas addresses on my resume with Mr. Wynn and Mr. Adelson and others. But the biggest challenge, and there's not a reason for that anymore. There's not this perception that the guys in the industry are necessarily and I'm always amazed where states don't try and recruit regulators rather than make these political appointments of lay personnel. So that's the historical reason. The scary thing to the industry is to take advantage of that, because these people basically don't know what they're doing. They just don't have a hint. This is a very, with regards to payment processing and then computer science and data protection and on and on and on. This is a complicated industry. So if the operators start trying to blow stuff by them, who's going to pay the price for that is the industry. Bad regulation hurts an industry because oftentimes the industry is kind of naive and doesn't self-regulate itself. So I think they ignore the fact that a lot of these people don't know what they're doing and just try and make sure they've got everything buttoned up before they get there. Plus the other agencies, and I did an article on this somewhat recently. In Nevada, they had a lot of turnover, 3 different chairmen in what amounted to 3 years. And that takes a lot of time of the staff to get them up to speed, and it's a distraction for the staff. But I just think typically a group like the DGE or the Nevada Game Control Board, those staffs are incredibly talented and know stuff, and they can provide a lot of support. It kind of ruins the whole notion of bifurcation, though, that separation of powers, because when you have a commission that doesn't know anything, really they just follow the guidance of I'm not the adjudicatory entity, but the compliance and enforcement division, and they kind of, you can end up with the board running the show or the DGE running the show, because the commissioners are just going to rubber stamp anything that comes along, which was kind of a surprising thing with the stoppage of the gentleman you mentioned recently, Gamebo thing, that was stopped at the commission level. That's unusual.
Very unusual, right? Yeah. So Marcus, when you take into consideration these, maybe not very experienced regulators, what kind of presentation should a company put forth? Should you kind of dumb it down and just this is basically what we do, but we do a lot more other things? I mean, how should a company approach their presentation to a regulatory agency?
It obviously depends on what it is that they do, right? If they're a studio or a platform affiliate or what have you, being able to show the experience, I think, is important, right? Mm-hmm. So, being able to say we are an expert in this specific field, and so therefore we're going to actually be adding to the market. We're going to be adding to your knowledge, dear commissioners, by bringing that. So I think not just talking about exactly what the business does, but what it has done and how that has helped another market. I think that's a big piece of it.
Right. What do you advise your clients to do, CJ, when they come to a presentation? Do you want them to touch on everything they do, or just the major things that they're going to do?
Well, I think in counseling the client, you need to know what's important to the client, and then advise them of what we think is important to the regulator. And like Marcus hinted at, it kind of depends on the specific context, what you're presenting, who the client is. As an example, right now with the expansion of sports betting and iGaming in the US, a lot of the motivation there is tax revenue, particularly with the pandemic. So, having discussions with regulators and presenting various things, if you're talking about a new market entrant, front of mind for a regulator might be, how are they going to grow our market? Are they going to cannibalize the existing market? So I think it does vary depending on the circumstances. But trying to put yourself in the regulator's shoes is always a key part of the analysis.
Right. Richard, when you were sitting on the California board, for example, what kind of detail did you want to see when people were submitting their services to you?
I was probably a bit unusual because I was pretty well prepared at every meeting. I was the problem child in the crowd, and
Right.
both with respect to the investigators and to the applicant. I would, and I could ask a couple of hours of questions. I was quite a pain. But I guess the point was a good law firm, and I would say, well, I won't use anybody that's Lionel Sawyer, for instance, going to a firm that's no longer in existence. They could tell you who was going to be a problem on the commission and kind of where you should prepare yourself to go and stuff like that. And that's why you hire able counsel or able consultants that kind of knows the ins and outs in the jurisdiction. Because, I mean, for instance, I probably emphasize DUIs more than most people, and a lot of people argued it was because I quit drinking 21 years ago. I don't think that had anything to do with it, but I just felt that really spoke to, and I'm not talking about a screw up, I'm talking about a repeated pattern of that activity. I saw it being very important determinant with respect to character, honesty, and integrity. And others didn't, so they'd, if you had somebody that had a problem in that area, that was part of the background investigation, they knew I was going to discuss it with them at length, everything from what their treatment routine was, when it had happened, and things of that sort. Do you know who Bill W. is? Think questions of that kind of sort. And a good lawyer will tell you where the traps are, But I pretty looked at everything, and my position on the California Commission, was in finance, and I both worked in finance and was educated in finance. So I'd normally, whenever the financial guy stood up to make his presentation, they made it to me, not to the ex-politicians who didn't have a hint other than political contributions. That was their only concern ever about finance,
So CJ, a few years ago, it was easier to get your product or your service approved in Indian country than it was in anywhere else, just because the regulatory systems were pretty spare bones and that kind of thing. I don't know if that's true for iGaming or the international companies coming in. How do you advise your clients when they come to this country? Do you say, maybe we should go to a tribal jurisdiction first?
Well, I don't know if that's necessarily the advice. I think it really depends on what the client's goals are. And, I wouldn't say any tribal jurisdiction is necessarily, an easier jurisdiction to go into or a good place to start. I do think many tribal jurisdictions, the scope of the applications that are required and how extensive that process is somewhat easier than commercial jurisdictions. I think approvals can be issued somewhat faster in certain tribal jurisdictions, but there's also caveats to that. An example would be, an operator coming from overseas, and let's just say they're doing a deal with a tribal casino to provide management services. Mm-hmm. So if you have a management contract there, that management contract then needs to be approved by the NIGC, and then you may need to be licensed and investigated by the NIGC. And that's a very detailed, extensive investigation, and that process can take quite some time. So it also depends on what services you're providing in that relevant jurisdiction or to that tribe. And as far as starting in a tribal jurisdiction, the other side to that coin is going into a jurisdiction like New Jersey, and I'll use your description as a gold star jurisdiction, and getting that stamp of approval from a jurisdiction like New Jersey or Nevada. Right. Because once you do that, and then you start going to other jurisdictions, it may make them more comfortable with you, with your product, certain jurisdictions, if you already have an approval, like from a New Jersey, they have interim licenses that the door is open to at that point. So, it really depends on the company and what their goals are, what their timing is. There's a lot of variables about, which way could make more sense.
Okay, great.
Well, and you should, they should, the international operators should understand that, if it's New York, you have to get gaming commission and tribal. If it's Arizona, same thing.
Right. Yep.
Right.
And then you also have to, they need to understand what sovereign immunity is all about. Right? It's a real business consideration.
Just to use California as an example, we had 109 tribes with 69 operating casinos against 66 different compacts. That gets complicated.
Right.
So Marcus, you've worked for a lot of companies with really cutting edge technology, and a lot of it requires, well, first of all, you're going up against commissions that don't really understand that stuff. So how important is it to have your technology tested by one of these testing agencies, either GLI or BMM or some of the others?
100% critical, absolutely critical. To the point where when I was at Gamblet, the first instance of product that we came out, they actually became kind of like an extended QA team because they were taking an approach that was set for a slot, and our games weren't slots, right? It had slot map underneath, and so that process of them trying to figure it out gave us the fodder to be able to explain it to regulators as we move.
Right. Well, and CJ, there's a lot of agencies that have their own testing labs, but does it still make sense to have it tested by an independent lab before you go into a specific agency testing lab?
Yeah, I think so. New Jersey's an example of a jurisdiction that will want to test and approve it on their own.
Right.
But I do think having the independent lab approval makes sense. You get to iron out any issues, you get familiar with the testing process. And then certain jurisdictions will rely on the independent approval, and they may simply ask the independent testing lab to just confirm compliance with that specific state's regulatory structure. So if you already have that approval from the independent lab, it can be an easier process. If you go into a jurisdiction like Iowa, then they can just add Iowa to their existing testing, and it can expedite things.
And there are jurisdictions that just employ these independent testing labs as their lab themselves.
Right.
So if you've already got approval by them, it's just a rubber stamp, basically.
Right.
Okay. So Richard, you mentioned earlier in the conversation here that there's been moves toward like a universal application form that everybody can use. But why has that not been really implemented even today?
Well, it has been implemented. I mean, that's an interesting story, and it's an interesting study as well about harmonization of regulatory processes, which is one of the favorite things of regulators to talk about, especially at the International Association of Gaming Regulators in those meetings. And it was the case that they had all these various different applications. I think it was Ohio or Iowa or someplace. It had to be on pink paper back in the days when I was doing this at one point, which meant that they had to hand it to you. You couldn't photocopy it or anything. But so starting with the American International Association of Gaming Attorneys, back when before it became advisors, they launched this project with a regulatory group about harmonizing into one contract or one application. And that's a great idea. And what happened was the final product was longer than any of the individual component parts. And so what they did is they just started stacking applications. I mean, they didn't simplify anything. It just grew in size, and then on top of that, you have to have an individual form for the release of information, so you can go to a bank and stuff like that. And that's a separate document on top of that. And then they have a supplemental attachment to the multi-jurisdictional form, which asks certain questions or causes you not to need to answer certain questions. And so that's one of those situations, Roger, the best laid schemes of mice and men have gone after you know, it just didn't work out. So
Gentlemen, thanks for the time. We really appreciate it. We've run out of time here, and hopefully we've gotten some information and some really good stories out to the people who want to apply in the U.S. So thanks for the time, and good luck with the rest of the program.